Hello and welcome everyone to my presentation on fitness for purpose in construction contracts. I am excited to talk today on this critical topic. This subject is highly important from the employers and contractors perspective as they are required to be aware of the specific terms of the contracts related to their obligations and liabilities to avoid future disputes. In this lecture, I will explain concept of the fitness for purpose related to design, materials and services provided for a project and what is employer's reliance in this respect. The court and the arbitral tribunal always look to the employer's reliance along with contract provisions while deciding a case in this respect. In the absence of any written provisions and conditions to the contrary, whether a professional is under an implied duty to act with reasonable skill and care while providing the design and services. Position under English legal system, for instance, the Supply of Goods and Services Act 1982 and some English court cases on this subject and reference to one Australian court case will be explained. Similarly, fitting forms of contract reference will be given in this respect. PI insurance and decisional liability insurance is also discussed briefly in comparison with fitness for purpose. I will discuss one important UK Supreme Court case on fitness for purpose to clarify the concept of this critical matter. Fitness for purpose defines the concept that goods or services must be provided or used for the intended purpose for which they were required and specified. A fitness for purpose obligation means that the contractor promises, warrants, and guarantees that the design and services will be in compliance with the employer's requirements. A promise that something will be fit for purpose may arise in three ways. Number one, by an express term in the contract. Two, by implication of the common law. And three, by implication of statute. The implication of a duty of fitness for purpose. The implication of a duty of fitness for purpose are, in respect of materials, we have to look that had the contractor supplied the materials fit for the purpose in the course of business. In respect of work executed, was the work and services of the contractor were fit for the purpose? Had the employer made known the purpose of the goods and of the works and services to the contractor, either expressly or by implication? Did the circumstances show that the employer trusted the judgment of the contractor in these respects and not its own? The court, DAB, and the arbitral tribunal will thoroughly review the contract as a whole to interpret the true meaning of the fitness for purpose provision, but ultimately it is the result rather than the method of achieving which will be decisive in determining whether fitness for purpose has been achieved. Fitness for purpose under English law. Under the English law, in the absence of any written provisions and conditions to the contrary, a professional is under an implied duty to act with reasonable skill and care while providing these services in accordance with the Supply of Goods and Services Act 1982. If the contract contains no express or implied fitness for purpose obligation, a designer is required to exercise reasonable skill and care in its design. This means that the design must meet the standard expected of a competent professional designer. Under the common law test for negligence, a professional is not negligent if he carries out his work to the same standard as another reasonable, competent person of his profession would have done. A reasonable skill and care obligation requires an employer to prove that the designer has been negligent. The employer has to prove that the design was not up to the standard of a competent professional designer. This question requires to be decided by a court, DAB, or arbitral tribunal taking into account evidence from the expert witness. Fitness for purpose and English case law. In the case of John Elliott and Wine Brothers, the court ruled that what the subcontractor had to do was to achieve a particular result, namely a support system which was fit for the purpose. The decision was in favor of the subcontractor. In another case of Greaves versus Bayham, Makel and Partners, the court clarified that the employer had specifically informed the contractor of the use to which the building was constructed. So the intended purpose was clarified, which was amounted to a implied term in the contract that the contractor will design the building accordingly. In one other UK case, due to the operation of forklift truck which the contractor was told to use on the first floor of the building, caused the floor to crack, the contractor was held to be in breach of an implied term that the design would be reasonably fit for the purpose intended. The claimant proved both purpose and reliance to the satisfaction of the Court of Appeal. Fitness for purpose Australian case law. In the Australian case of Viking Grain and T.H. White installations, a grain drying silo which the contractor designed and constructed was subject to water seepage into various below ground structures, rendering the silo unfit for the grain drying purpose for which it was intended. The court held that the contractor is liable under the fitness for purpose principle, since it had been told the exact purpose for which the silo was to be used and the employer had placed reliance upon its expertise to make it function correctly. The court in this case qualified the fitness for purpose requirement by saying that the obligation to design a product fit for its purpose is directly tempered by the fact that only reasonable fitness was demanded. Fitness for purpose and FIDIC. Under FIDIC forms of contract, silver, yellow and gold books, conditions of contract for EPC and turnkey projects of the design and build operate clearly contains fit for purpose obligation. Subclass 4.1 paragraph 1 states as follows: when completed, the works shall be fit for the purposes for which the works are intended as defined in the contract. The contractor is advised to be clear where these purposes are incorporated in the contract, and it must be ensured that these provisions are expressly, narrowly and precisely defined. PI insurance and fitness for purpose. Professional indemnity insurance policies available to contractors and designers contain express exclusions that may mean that any assumption of a fitness for purpose obligation will result in the designer not being covered under the PIE policy for a breach of an absolute fitness for purpose obligation. Contractors should be aware whether their PIE insurance excludes cover for fitness of purpose obligations. They may look at extending their PIE policy to the specific project with a fitness for purpose clause, or alternatively, they should look at counterbalancing the risk by seeking to limit their overall liability under the contract. Fitness for purpose and decennial liability. The Civil Code of Spain and UAE both provide for decennial liability containing 10 years guarantee for the stability of structures. Decennial liability amounts to an implied fitness for purpose obligation. The precise scope of the decennial liability varies in different civil code jurisdictions. Under the Spanish Civil Code, if a structure has collapsed due to a breach of the contractor, then the contractor's responsibility will be extended to 15 years. Decennial liability will not apply to other functional characteristics of completed works. Other aspects of responsibility will be regulated by contract. Fitness for purpose obligations are not insurable. Decennial liability is a standard regulated in detail in the jurisdictions where it applies. The scope and application of decennial liability is certain and limited. Therefore, insurance companies can offer insurance cover. Fitness for purpose obligation is difficult to insure, even in countries with a decennial liability tradition in their legal systems. English case law, fitness for purpose. Facts of the case of M.T. Howard and E.ON Climate and Renewable UK Robin Riggs East are as follows. E.ON, the employer, employed Howard, the contractor, to design and build the foundations for the wind turbines. The contractor designed the foundations as per the International Industry Standard J101. After execution, it was discovered that J101 contained a flaw. Under the contract, the design of the foundation was to be insured lifetime of 20 years. At the first court of instance in 2014, the contractor sought a declaration from the court that it had complied with its contractual obligations. The court ruled that the contract contained a fitness for purpose obligation. Therefore, the contractor was in breach of that obligation, as the turbine bases did not have a service life of 20 years and so was liable for the remedial costs. The Court of Appeal in 2015 upheld its appeal. The Court of Appeal said that the contract required only that the foundations should have a design life of 20 years, meaning that they would probably but not necessarily function for 20 years. This was not a fitness for purpose obligation, and so the employer was liable for the remedial costs. The Supreme Court in this case decided that the contractor is liable for the cost of remedial works and overturned the decision of the appeal court. The Supreme Court reached this conclusion for three reasons. As a matter of law, if a contractor agrees to both work to a specific design and to achieve a specified result, if the design does not achieve the result, the contractor will be in breach. The technical requirements specified that the standards it set out were minimum requirements, and that it was the contractor's responsibility to identify and additional or more rigorous requirements. The Court of Appeal's conclusion that the wording of the technical requirements was too slender. A third was wrong. There were clear words in the contract that indicated that the contractor was to achieve a 20 years design life. Conclusion. It is important for a designer and contractor to understand what in fact agreed to, particularly in complex and bespoke contracts having various technical documents which inevitably will contain conflicting provisions. The contractor must ensure that he understands his responsibility and liability related to the design and construction, whether it is fit for the purpose or merely complying to industry norms. Purchasers must be careful in specifying particular standards concerning the design, materials, and services for achieving specific outputs fit for purpose. For determining liability between parties, the contract wording is very important. If a contractor has cover under its PI insurance, then he may exclude cover for fitness for purpose obligations. The contract draft must be clear, specific, and of simple wording which will help avoid disputes. Thank you.